So if something happens to my client, that individual is ready to jump in. They're not running around all confused. They say, oh no, I know I've been named as guardian, or I know I've been named as successor trustee. The other reason that's important too is if something happens to one of my clients, there will be questions. That's just what happens when someone passes away.
Welcome back, friends, to the Erie Wellness Podcast, where we explore a wide range of wellness topics, highlight the incredible local professionals in our community, and encourage you to advocate for your health and well-being. This week, we're stepping into financial wellness in a way that hits a little deeper, protecting your family, your assets, and the life you've worked so hard to build. Today, I'm joined by Emily Ferrell, founder of New Parent Law. She's a mom, a business owner, and someone who understands what's at stake here. Her work focuses on helping families, especially those with young kids, hence the name New Parent Law, put a plan in place so that if life takes an unexpected turn, everything is already handled and in place. Welcome to the podcast, Emily.
Thank you, Lauren. It's a pleasure to be here. Thanks for having me.
So you are a mom as well. So I actually first got introduced to you. You were a sponsor at a local school here in Erie and saw your booth, and you were just sharing with parents. So what is the age of your daughter?
Yeah, thank you for asking. I am a mom. I'm deep in it right now. So my daughter is 3.5. She'll turn 4 this summer.
I always love hearing the why behind what people do. So what led you, Emily, into this area of law, and why new parents specifically?
I love that question, Lauren. And I'm glad you started asking me about my daughter too, because so much of it is interconnected to my personal experience. So as parents, when we have our child, what happened with me, and I think what happens with a lot of us, is we think, oh my goodness, I'm now responsible for another human being. And it's a joy, but there's a lot of responsibility that comes with that. And suddenly we realize, well, if something happened to me, what does that look like for my kid? Who raises them? What does it look like for them financially? What does it look like for them in terms of their inheritance? Do I need a will? Do I need a trust? Maybe you've heard a little bit about a trust and have no idea where to start. I think all of that can be incredibly overwhelming, right? And that's on top of trying to figure out breastfeeding or what daycare to get them into. Right. So there's a ton of pressure on us new parents. And one piece is this legal side. Is my child protected legally and financially? And what about my spouse as well if something happened to me? Are they protected? Can they continue to live in the lifestyle that they want to live and parent our child? Mm-hmm. And so why I founded my firm, New Parent Law, really has to do with capturing people in that phase of life where we know we need additional legal protection. Maybe we don't know where to start. And it is so crucial for us to make sure that our families are protected legally and financially, our spouses, our partners, and especially our children. So that's really why I founded New Parent Law, to focus specifically on that phase of life. I do work with individuals and clients in all phases of life, but my key target, my really favorite, is working with those new parents. And I do occasionally have clients come to me who are expecting their first, right? So they haven't even become a parent yet. And I love that phase of life as well.
Right. That's almost easier, in my opinion, because you haven't entered into the diaper changes and being up late at night. Your train of thought, I think, is a little bit more clear.
Yes. And so when that happens, we talk with them, we get a plan in place. We try to sign it right before their anticipated due date. And then I always talk with them, well, I'll reach out when your baby is 6 weeks or maybe 2 months and you start to, I'm going to put things in parentheses, have things under control a little bit, right? Because things are never really under control as a parent. Right. But maybe that's a good time for us to check in and revisit and figure out, once you have your baby, are there additional updates we need to do to your plan?
Mm-hmm. No, absolutely. And a lot of families here in Erie are in that stage. So they have young kids, busy schedules, and this can always easily get pushed off for sure. For a family who just had a baby or is adding another child to their family, what is the very first legal step they should take, in your opinion?
Great question. So in my opinion, it's really going to depend on where they are. Do they already have a plan in place? Have they thought about this? I would recommend, though, that everyone just start with reaching out. Give us a call, jump on a 15-minute consult. There's no obligation. I think it's really important to learn what you need to learn. And even if you don't know what you need to learn, do I need a will? Do I need a trust? Do I need a guardian? What if I already have a plan in place? Do I need to update that to account for the new baby? So it's really important to learn what is out there, what your options are, and maybe what you need to consider. And the first step to doing that is just reaching out, seeking out that legal advice.
Yeah, you don't know what you don't know kind of thing.
Exactly. And I think it can be really scary, right? Maybe it's a rabbit hole you don't want to open or go down. And this too, Lauren, just thinking about it, and you inviting me as a guest on this podcast really speaks to how important that legal and financial well-being is to just overall wellness. And I think it depends on all of us, right? This unknown. Well, what would happen if I don't have a plan in place? Maybe I don't even want to take a look because it really scares me. But that doesn't address the problem. That doesn't make it go away. So I think it's really important to approach it head on. I do try to make it as easy as possible. I realize it can be incredibly overwhelming.
Right. There's a lot to think about. But like you said, it's, reducing the stress of like constantly having this like dark cloud overhanging you, like what needs to get done and like what, all these things and unknowns. I think that can put a lot of stress on you too. So for your overall peace and wellness, just to kind of know what the options are, have a plan in place, knowing you can always change it, and go on from there.
Exactly. And you really hit upon it too, Lauren. You can always change it. As long as you are alive and have capacity, you can change your estate plan. I anticipate, in fact, that my clients will change theirs multiple times because life changes a ton, especially for all of us with minor children. So as we think about it, things that likely would change is who's a part of our family, right? Maybe we will have new kids between now and the time, down the road in a few years. Maybe we'll have new spouses. Maybe people in our lives will no longer be a bigger part in our lives. And so we might want to remove them from our plan. Things that I anticipate clients will update as well as who's named as guardian of their minor child, right? Who we name today, right? When my daughter is 3.5 might look very different than when she's in high school at Erie High School. And I might just want to name the parents of her best friend because if something happened to me, I want her to be in school and just get through high school. That changes. And another big piece that changes too is where we all are financially. For us with minor children, we tend to be in our wealth accumulation years, right? So probably our highest earning years anticipated for the next few decades. So what our estate looks like and our assets look like today will look different in 5 years, in 10 years, and when we're 80, it'll look totally different then. So I do anticipate clients will update their plan multiple times.
No, it's a really good point. Even parents, I feel a lot of people probably would elect like one of their parents to take care of their kids or something like that. But as they age, are they really fit and can handle taking care of kids in high school and all the things? Or, maybe one of your siblings now has 5 kids, and you're like, I really can't add an extra 3 to what they're already taking care of. So just trying to figure out all of that. No, it's a good point.
Absolutely. Yeah. All of that changes. Absolutely.
So not to scare parents, but what actually happens if guardianship isn't clearly documented, and how should parents, go about choosing a guardian? And can guardians, well, you mentioned they can change as your life kind of changes as well.
Great question. So when you're talking about guardians, and I want to expand on this a little bit, we'll start with talking about long-term guardians. I think it's also very important though to talk about temporary or short-term guardians, which tends to be overlooked in more traditional estate planning. And when I say more traditional estate planning, where you go down, maybe you sit down with an attorney at an office, give them a few names, they'll kind of draft up traditional documents and say, here you go, sign. What I do is more complex than that. And it's because I want to make sure that I put a plan in place that works, that that I know works. So your family will be taken care of, your kids will be taken care of, your assets will be taken care of if something happens to you. That is incredibly important to me. So when we're talking about guardians, 2 types of guardians, long-term guardians and temporary guardians. So starting with long-term guardians, these are the individuals that if something happened to you, or if you're co-parenting, you and your partner, you and your spouse, if something happened to both of you, these are the individuals that would step in to raise your kids. So usually for my clients, this is the biggest and most important role that they nominate in their plan, right? These are the people that we trust incredibly to raise our kids. If you don't have a guardian nominated and something happens to you, you pass away, or you become seriously incapacitated and someone has to step in and take care of your child, you're in a coma, you have a traumatic brain injury, and are unable to, essentially in the legal world, we call capacity, you don't have capacity. We need someone to step in and be able to raise your kids, right? Or sign the permission slips, bring them to school, be able to bring them to the doctor. If you don't have a long-term guardian nominated, we don't know who that person's going to be. And I know that's scary. And that's why I want to share this with people ahead of time, because as long as you're alive and have capacity, you can do the planning, you can have a say over what happens to your family. If you don't plan, that's where it gets really scary. What it looks like is then the matter would go likely before a judge, a county court judge. So in Erie, typically we have two counties, Boulder County and Wells County. So if you're in Boulder County, it would be at the Boulder County Courthouse, downtown Boulder. If you're in Wells, it would happen up in Greeley at the Wells County Courthouse. And then it would be a judge, likely someone you've never met before, who's essentially determining who raises your children. And that can be really scary. Now, under Colorado law, there is what's called the best interest of the child standard. So the judge will look at what's in the best interest of your child. And there are some somewhat measurable factors there. But I think what's really scary is what the judge that's never met your child before determines is in the best interest of the child might not be what you determine is in the best interest of your child. So what are your priorities if something happened to you? Would you want your child to be raised by family? Would you want your child to stay in Colorado? Would you want your child to be raised by someone in the same faith? Would you want your child to be raised by someone who has the same educational values? So all of these factors might have different values to you that aren't necessarily to a judge.
No, those are some good questions to talk about, yeah, those are some big ones.
Yeah. And the reality too, Lauren, is I rarely see clients who come into me and say, we absolutely know who we want to name as guardian, because it takes a lot of discussion. I've done this with my own husband. It can be a tricky discussion to have of, well, who do you think would be most appropriate? Who do you think, especially when we start talking about family, right? Is it your side of the family? Is it my side of the family? What does that look like? I work with my clients to help foster these discussions. And so I can give them strategies. We can talk through certain factors, and then we can also put conditions on it. Maybe it would be, I want this person, so long as they're able to move to Erie, so that I can value that continuity for my children. They can stay in the daycare, they can stay in Erie Middle School, wherever they are. Or maybe it's, I want it to be my parents, so long as they're still below the age of 65, because after that, I think it would be really difficult for them to be active in that child's life, whatever it may be. So there's no one, it's got to be this person and that's it. I really help my clients walk through those discussions.
Right. So, and two, you have to also ask these people too, right? You can't just be like, guess what? We signed you up for this and you don't know, but it's in our, So how do you have those conversations too? Like, honestly.
Yeah, that's a great question. Best practice is to ask the person, get their permission. The reality is, even if you nominate someone as long-term guardian and something happens to you, a court will say you have been nominated, right? Lauren really wanted you to raise her children. Are you okay with that? So they do have to accept it. So what I tell clients is, we're not forcing our children on anyone. They can always say why. So yes, let's talk to them ahead of time. What I think makes it a lot easier is if you can sit down with that person and say, look, I've worked with a really competent, comprehensive attorney, and I've set up a plan so that the financial piece is taken care of. What I'm asking you as guardian is to provide love to my child, to drive them to soccer practice, to pick them up from school, to give them all the hugs that maybe I wouldn't be there to give them. But I'm not asking you to spend your own finances. I've set up this comprehensive plan. Usually it would be through a trust, and I can talk more about that. So someone will be in charge of the finances. It might be the same person, it might be a different person, but we're not asking you to essentially spend money that you've been earning for your kids now on my children. I just want you to provide them with the love that I might not be able to do so if I'm not here.
So how do you create that like financial wellness piece? So our next question was like, what should families be thinking about now when it comes to the inheritance, even if, it feels far off?
Yeah, great question. So hopefully the inheritance piece is far off, and hopefully you don't have to think about it. And my hope is we're all here when we're 80 talking about updating estate plans and talking about planning for your grandkids. But the reality is we don't know what life holds. So we hope that it's far off and we don't need it. But the reality is we could need it to kick in tomorrow. We just don't know. And so we want to make sure we're prepared. What it looks like with inheritance, I find this area of law fascinating. It's a complex puzzle. There are multiple ways you can put a plan in place. If you do not have a plan in place, under state law, the Colorado Probate Code would kick in. The issue here is most people have not read the Colorado Probate Code. It's kind of a dry read. I totally understand. But what we risk is this state law kicking in that impacts our children if something happens to us and we have no plan in place. And it's a state law that we've never read, and we probably don't even know what it says, right? For most people.
Right. It's not a baby book. You're like reading ahead of time, right?
Exactly. And that's the reality. If you don't have a plan in place, the state has a plan in place for you. The issue is you likely don't know what that plan is. You may not agree with that plan. And once you pass away, if you don't have a plan in place, it's too late to change it. There's really very little we can do. And that's why we do this proactive planning. So what that looks like with children, for example, is making sure that if something happens to you or you and your partner, again, if you're co-parenting, they don't inherit a lump sum. So under the Colorado probate code, if you have no plan in place and something happens to you or you and your partner, if you're, again, co-parenting, what that looks like is by default, it'll go to whoever the Colorado probate code says your asset should go to. Let's say that is your children. The issue there, right, for me, a 3.5-year-old cannot inherit a lump sum, maybe for better or worse. She's in a princess phase right now, my daughter. So if she could, and she knew how to use a credit card or a bank account, a lot of that would go to princess dresses. So my thought is, okay, maybe it's good that she can't inherit that outright. The downside is that with no plan in place, Colorado will set up what's called a conservatorship for your child. It essentially will be this legal entity. It's an agreement with an individual and through the courts. The conservatorship will hold that inheritance for your child. And there will be a conservator appointed, and similar to guardian, we don't know who that conservator would be. We hope it's someone we know. We hope it's someone we trust. But if you haven't done more planning, we don't know. You're leaving it up to fate. So conservator will be appointed. They will manage the conservatorship for your child. And then here's where it gets really terrifying, in my opinion. Your child would receive that and inherit it as a lump sum outright at age 21. At 21, I think back to myself, and I think I was a fairly responsible college student, but I still would have had no idea what to do with a lump sum inheritance. And so they get that at 21. And when you think about that, that can really derail a young adult's life. So with inheritance, you can put a trust in place that would really stretch out the inheritance. And you can put it in place for a few years. You can put it in place for life to protect it from that child's future creditors. And when I say future creditors, I'm talking about lawsuits. I'm talking about future potential ex-spouses in the case of divorce. So there are some really amazing things you can do through planning.
So you really have to think ahead, like what could happen to them over the course of their life, and how do I want that inheritance to be laid out for them?
Exactly. And that, Lauren, is, I tell clients, that's my job. I think of all these hypotheticals. And as we talk and design their plan, I hear a lot from my clients, oh, I've never thought about that. And that's fair, because as you're going about your daily life, why, I hope, right? And why would you be thinking, I hope you're not, and why would you be thinking about, well, what if something happened to me? What if something happened to me and my child? What about this? What about that? What if something happened to me and then my child gets married and then they get divorced? There's so many hypotheticals out there, and that's my job, to think through all of these to make sure that your family is protected.
How many hypothetical, I mean, because then you can kind of start going down rabbit holes, right? So, what is a good hypothetical range, essentially?
Great question. So what's really important, I think, is that we put a plan in place that honors your wishes. So we put the individuals in place that would kick in if something happened to you. We know who would likely be raising your child. We know who would likely be in charge of your child's finances through a trust. We know who would be making the medical decisions for you if you're incapacitated. That's a big one too, right? If I am in a coma, who's making the medical decisions for me? Am I leaving that up to chance? I don't know who it is. Or do I want to proactively plan? Is it my spouse? Is it my sister? Is it a girlfriend, right, from college that I'd want making my decisions? So we want to make sure that we have a plan in place. We have strong individuals in place. And then it's a balance of making sure we have a plan that will honor your wishes, but can also adapt, right, depending on the hypothetical situation. Right. And that's why I encourage individuals to work with attorneys, to work with legal professionals, because it is so complex.
Right. Because I was even thinking about college. What if your kids, who knows what college is going to look like 10, 20 years from now? I feel like people have been saying that for a really, really long time now, but say it's still like it is today and it's a 4-year institution, it's expensive. But what if your kids get a full ride? Then how do you reallocate the funds? What can they be used for if not for school? All of those things too.
Exactly. That's a great question. And so when we design a child's inheritance, I talk with my clients because I want to understand their priorities. So what are your priorities? Is it to make sure that your child has money for education? And when we talk about that, is it a 4-year college? Does it include trade and vocational school? Does it include advanced education like medical school? So again, it starts getting more complex. But what are your other priorities? So let's say they take up pole vaulting, right? Kind of a random sport, which I love. They are able to get a full ride to college because of that, right? Which is great. I have one friend in high school who did that. And I thought, oh, I should have taken up pole vaulting.
I know. I thought that with golf. I was like, I should have gone and be a golf caddy. I could have had it.
Exactly. Exactly. So let's say your child does get a full ride, and this is a situation in which you're not here, you've left in their trust for them that the trust would cover education. Okay, so that money's not used now on education. Were there other priorities for your child that we had built into your plan? Was it, well, maybe I want to assist them in buying a house, but maybe I'm going to limit that. Maybe I only want the trust to pay for up to 20% of the house price, such as a down payment, and only
Mhm.
show the trustee that they can afford the mortgage. So they can't go to
Mhm.
the trustee and say, oh, I need money from my trust to buy a $2 million chateau in France.
Right.
We want to shape it to really honor your priorities. What do your other priorities look like? What I love, one of the pieces I love too, is when I see families with multiple kids and they want to talk about a way to keep their children together, maybe in their 20s or 30s, if the parents aren't here. And so I occasionally see building in with clients is money for those children to take what's called a sibling trip every year. So we think about
Mhm.
a world where the parents aren't here, the siblings, your children are in their 20s. Well, maybe we allocate $5,000 to each child so they can bring their spouse or their children on a trip now with their siblings. So really a way
Mhm.
to keep the family together. So there are some really interesting things we can do when we're talking about a child's inheritance.
Mhm. No, I love that. That's a great idea. Or just having like a landing place for everyone, to come and stay if you're not able to be there at the house. So,
Absolutely. And it's again getting to your priorities. If I'm not here, what would I want to make sure my children honor and I instill in them? And I love having these conversations with clients too, because in our everyday lives, it's not something we take time and pause and think about. Do I
no.
want to make sure I'm prioritizing education? Is it really important to me that my children remain strong and bonded? And so, even just having these conversations to put into an estate plan, I think can really bring some clarity to your everyday life as well.
Absolutely. And just start talking about those things. And probably even as the kids get older too, and you start making these adjustments, they're teenagers, they can have a little bit more input. You can start asking them these questions maybe too.
Absolutely. I love that. Something I do too, Lauren, just thinking about starting to involve your children, is I offer for my clients family meetings. So this is a chance. Do you want to involve family members? Do you want them to come in for a meeting? Let's talk
Mhm.
about the plan. Where I see this come up is with my clients who have adult children. So as I mentioned, I work with people in every phase of life. So clients who maybe have 40 or 50-year-old children will sometimes bring them in, or sometimes we'll sit down for a meeting. And that can be really helpful too in terms of talking about intergenerational planning. So not only
Mhm.
do we talk about, okay, if your parents aren't here, what does it look like for your inheritance? But is there anything that you need to know about their plan to incorporate into maybe your own estate plan? And that can get really complex and involved as well.
Mhm. And maybe the financial needs of one sibling looks a lot different than the other, and they're willing to say, I'm really set up financially here, and if you need more help, I'm willing to switch some things over for you. So,
Yes, I love that, Lauren. And I love that conversation amongst siblings. And I think where it comes up too is, maybe it's we're doing okay. We feel really fortunate, but where it could be really helpful is planning for our children and to make sure that their education is covered or whatever
Mhm.
that looks like. So thinking about ways to, if now we're starting to talk about grandparents, that they can plan for several generations.
Right. So, what would you say are some of the common mistakes you see families make when setting up accounts or their assets?
This is really important, Lauren. When we talk about estate planning, we rely heavily on either beneficiary designations, which, as we think about, typically tend to be when we set up a retirement account, it will
Mhm.
usually, 401k, it will usually ask us to name a beneficiary designation. And I
Mhm.
remember in my early 20s at my first job, I didn't have a partner, I didn't have a spouse. So I kept naming my brother as my beneficiary designation. And then I have to call my mom for a social security number and the whole thing.
Mhm.
We talk about beneficiary designations heavily in estate planning. And we also talk about funding. And funding is the legal term for when you set up a trust, essentially moving assets into the trust. And it's called funding the trust. That can happen through changing the name on an account into the name of the trust or naming the trust as a beneficiary. So we rely heavily on beneficiaries and then funding. And that involves titling assets. It's really important that if individuals are working with an attorney, in my opinion, the attorney will talks with them through how to title assets, how to add beneficiaries, how to fund their account. That is a huge
Mhm.
step. If you work with an attorney to set up a trust, typically it tends to be a revocable living trust, and the attorney does not provide funding recommendations, to me, that's a red flag. And I would recommend following up with the attorney and saying, well, okay, now how do I fund the trust? If you set up a trust and you never fund it, it will not work. And this is one of the most common mistakes I see in estate planning. I'll see clients come to me, ask me to review a trust that they had done years ago or in another state. And I say, the trust itself might be great. How are your assets titled? How are they held? And if it's all in the person's individual name, that can be really problematic. So again, this is where it gets more complex. It's really important when you're talking about accounts and how to set up accounts or title accounts. So some common mistakes I'd say is if you have a trust set up, the trust is not properly funded. Accounts are not properly titled into the name of the trust, if that's what the attorney has recommended. Where I see other common mistakes is that a spouse is not properly included. And this can be really problematic. I see this with clients who come into me. They haven't worked with an attorney prior, kind of were starting fresh, and they might have a checking account or a savings account in their individual name. And what I ask them is, do you have a beneficiary listed? On a bank account, it's typically called a payable on death. And that essentially means if I pass away, this account should be transferred to this person. This is the beneficiary designation.
I don't think I've ever seen one of those.
Yeah.
What's it called? A payable on deck?
It's called payable on death. So what
you have to request it?
You will have to set up your account with it. So just a little disclaimer, because I'm an attorney and I love disclaimers. This is not legal advice for anyone. If a client of mine is listening and they have questions, they're welcome to call. If someone's listening and they're not a client, they're also welcome to reach out and we can kind of talk with them about working with them. But what is really important for people to know, just general education, is on bank accounts, most savings accounts and checking accounts will allow you to name a beneficiary designation. A beneficiary designation is what kicks in when you pass away. So that instead of your account now going through probate, it goes automatically to the person you've named. On a bank account, it's typically called a payable on death. So for example, if you use Chase for your banking, you can usually log into your online portal, in the search bar, put payable on death, and you can name someone. And typically it only takes about 30 seconds. You usually need to know their name, social security number, and birthday. That's really important. And where I see spouses making a mistake is they hold an account in their individual name and they have not added their spouse as a payable on death. I'm not talking about necessarily adding the spouse to the name of the bank account, just as a beneficiary designation. Right. So let's say, Lauren, you have an account in your individual name and you pass away. It could get stalled in probate and your partner, your spouse, could have trouble accessing that unless they're named as a payable on death as a beneficiary. So that's one common one. And the fear there is there one account, maybe it's in your name, maybe it's in your spouse's name, that people pay a mortgage from, right? And if something happened and now that account is frozen, are you going to have issues paying your mortgage, right? While you're also grieving a spouse, now you're running into financial implications. So it's really small little changes like this that people don't know to do. And I completely understand. And I'll talk more about the lack of education about all of this, but small little changes that can make a huge difference. So a beneficiary designation is a big one. And I see that come up with spouses. Another one I'd see is, maybe as older individuals adding an adult child to the bank account or to their title of their house. That is something I would recommend not doing. That can be very problematic for certain reasons. So there is a lot that goes into how we title accounts, how we name accounts, who we name as beneficiaries. And again, it starts to get more and more complex.
One of the listener questions that we had was, what is a trust? So can you explain that to our listeners?
Absolutely. I love this. I love every opportunity to talk about trusts. And I think my friends and my husband are tired of hearing me talk about them. So I'd love to. I will simplify, but in general terms, there are two main types of trusts: a revocable trust and an irrevocable trust. Most individuals, when I talk with them, we're talking about setting up a revocable trust. It's called a revocable living trust. A revocable living trust is a foundational building block to an estate plan. Essentially, you set up the trust, which is through usually about a 100-page trust agreement. And it's an agreement between three parties: the grantor or the trust maker, so the person who sets up the trust; the trustee, so the person who manages the assets; and then the beneficiary, the person who benefits from the assets. You build this trust, and you can think about it as a child's beach bucket, one of those neon buckets that you bring to the beach. I grew up near a beach, so that was a staple of my childhood. So the child's beach bucket, that's the trust. And then you have to fund the trust, and that's essentially moving assets into the trust. If you do that, you set up the trust correctly, you fund the trust correctly, when you pass away, what's in the trust will avoid probate. So it is a really incredible, helpful estate planning tool.
Can it
Was
be even cars and all kinds of stuff, right? Like inside.
That's a great question. Exactly. So how you fund an asset into a trust is going to depend on the type of trust. And I work with my clients. If we build a trust for them, I will always provide, I'll go through every asset that they've listed and provide a funding recommendation. It will really depend. For example, bank accounts, we might move directly into the trust. So we might change title on the bank account to the name of the trust. Something like a qualified retirement account, like a 401k, we will not move into the trust because that has tax implications. So instead, may name the trust as a beneficiary on that. So this is where it starts getting really complex because we're talking about the legal side. Can we avoid probate? Can we protect your family correctly? And then we're also talking about the financial implications, primarily the tax implications, which start getting really complicated as well.
But you don't want to get stuck paying huge, you don't want your family stuck paying a bunch of taxes after you've passed just to get some of those assets out. So it's good to talk about it and figure out what needs to be in there.
Absolutely, absolutely, Lauren. And this is why part of the reason why I encourage this proactive planning is because we are all working so hard to whatever it is, build up our estate, support our families, allow our children to go to college or whatever it might be, our priorities might be. And my goal is to make sure that your family's protected and that your assets don't get lost if something unexpected happens to you. And so where we can see this happen, like you're talking about, is with taxes, right? If something happened to us and the estate isn't set up properly, are we risking these incredible tax bills? Are we having unnecessary early withdrawals from retirement accounts? We're getting taxed on them. What does that look like? And then on the other piece, are you getting stuck in probate? And probate is the legal process essentially of a court administering a person's estate when they pass away. So when someone passes away, we may need to go to probate, and that again would be in Wells County or Boulder County for Erie residents. And it can take years. Houses can foreclose during probate. It can be a mess. And so how do we avoid probate? Because not only can it be a mess, can we lose assets during it? It might get really expensive. And where I see it get really expensive is when you need to involve a probate attorney. And so you might have a large estate and you might think, oh my gosh, if I pass away, I don't need a plan because my kids are taken care of. There's plenty in there. But do you risk losing that during probate or to taxes? And so let's make sure your plan is set up correctly to make sure what you do have is properly passed and in a responsible manner to your children.
Right. Yeah. No, you want to be a good steward of your money while you're alive and afterwards as well. So
that's a really good way to phrase that. I love that.
No, it's like, I don't mind paying taxes, but I don't want to give any more taxes than I have to. Like, I want to be a good steward of my money. So,
yeah. And Lauren, I love that you're bringing this up too. There can be state level estate taxes and federal estate taxes. And what that means is when we pass away, a state may tax our estate or the federal government may tax our estate. And in Colorado, we don't have state level estate taxes, which is great. But if you are thinking about moving to another state, although why would you leave Erie? But let's say you are thinking about moving to another state, you do need to be careful of those state level estate taxes. And there is a federal estate tax, which means when you pass away, your estate will be taxed unless you're below a certain amount. It's called the exemption amount. So you do need to be careful of that as well. We offer free consults. So anyone's welcome to set up a free 15-minute call. We'll talk about next steps. And then I love meeting with the community. So I also offer free workshops and presentations often. One of my favorite was last month at Old Mine, downtown Erie. We had about 60 people turn out. We talked about, what is a will? What is a trust? What do you need to consider with estate planning? We also did it over pizza and drinks. So it makes it very approachable. I want to make sure it's approachable. It's not as overwhelming. And we really work with you through that whole process.
I love that. And people then maybe are asking questions you wouldn't have thought of, but you were like, that's such a good question. I didn't think of that. I'm glad you asked it. One misconception, though, that I did want to point out is I feel like a lot of people just think this is so expensive. Like I can't set it up. Can you debunk this is too expensive for me?
Absolutely. That's a really good question. My response there is the stakes are too high with this. The stakes are too high to ignore it or to go on ChatGPT and say, write me a will. And I will say right now, will not, that is not an estate plan. So just so we're aware of that too, that's not going to protect your family. The stakes are too high that it's really important that you talk with a legal professional. I try to make it as approachable as possible. And what that looks like is I offer flat fee packages. So a lot of attorneys will charge hourly, and that can get tricky of like, well, how long will it take? So what will my bill be? I just say, this is the flat fee. And I work with my clients to find a fee that feels good to them. And what that looks like is we can add in different layers of trust, and there'll be an additional charge for that. So it'll provide more protection, but maybe your focus right now is let's make sure at the core, my family's protected. And then maybe in future years, we'll add on those trusts. I want to know where they are though. So that's the flat fee rate. So there's never a surprise bill at the end of the month. And then I also don't charge hourly. So if someone has a question, I want them to feel comfortable picking up the phone and giving me a call, not being like, oh, I need to talk quickly because Emily's billing me for this call. Right? I want to make sure that if they have questions, they feel comfortable coming and talking to an attorney. I will also say, right, when we start talking about, well, if you don't put a plan in place, the cost is going to be much, much more expensive. And what that looks like is if your assets get stuck in probate, we estimate that probate will cost anywhere from 3 to 15% of your overall estate size, which can be tremendous. So when you start to think about your estate size, for many people, it's larger than they expected, right? We think about, well, what about the equity in your house? What does that look like? What about your retirement accounts? Do you have a life insurance policy? So even if you have a term life insurance policy, let's say that's $1 million, well, now your estate is well over $1 million. So when you start talking about 3 to 15% of that overall amount, the cost for the as you can start to add up and calculate can be enormous.
No, that's a really good point. Put in a little bit of extra time and money into this, but in the long run, it's really going to pay off.
Absolutely. And I think it goes to the core of, well, why do we do estate planning? Why do we take our time thinking about this? A lot of it can be for yourself. I want to make sure that if I'm incapacitated, who I want to make medical decisions for me is the person making medical decisions for me. When you do your estate plan, this weight is lifted off your shoulders. It's incredible, I think, how much we carry that around without realizing it. So it can be for yourself, but why I see a lot of people do it is for the ones they love, their partner or spouse, their kids. And it's really this act of love in doing your estate plan. It's saying, if something happens to me and I'm not here, you will be taken care of. And I'm making sure that you will be taken care of. I approach it the same way as thinking about life insurance. And why do I make my monthly premium payments on my life insurance plan? It's a gift to my husband. If I'm not here, you will have the financial ability to live the life you want to live and raise our daughter and focus on grieving and taking care of our daughter and not worried about, oh my gosh, how am I going to pay the mortgage?
No, it's a good point, a good analogy. This is a gift really that I'm setting up for you so that you're not having sleepless nights trying to figure these things out. So.
Exactly.
So we wanted to touch a little bit on generational wealth. So what does that actually look like for an everyday family?
Great question. Generational wealth, and I think this term is thrown around a lot, especially I'm also on social media, and I'll get these different posts, and that's part of the algorithm that I'm fed. But I think it's thrown around a lot. And I think people tend to have this misconception of, I can't build generational wealth unless I inherit a large lump sum or I come from a rich family, right? Maybe generational wealth isn't for me. And that's completely untrue. And generational wealth can be built, and it's typically built through these little conscious changes and little conscious steps. So what that looks like is starting to learn, maybe if you haven't, about compound interest. Well, what is compound interest? What does that look like? Is there a way that you can start helping your child with compound interest? So maybe you have a teenager who's out there working. Well, that teenager can set up a retirement account, right? And I think about, wow, if I had set up a retirement account when I was 15 and working as a lifeguard and a waitress, that would have been so helpful in terms of the compound interest. I didn't have that education. So I think in terms of building generational wealth, a lot of it comes down to educating yourself, seeking out that education, and then making these little steps. Other things that can go a long way, for example, is adding, if you have good credit, adding your child as an authorized user on your credit card. Not adding them to the account, but adding them as an authorized user, because now your good credit on that credit card will impact them. And so when they turn 18, suddenly they'll have a credit history. And you think about how helpful that could be in terms of trying to qualify for a better mortgage rate or a better rate when you finance a car. So it's really these little changes that go a long way in terms of starting to build generational wealth for your children.
And it's good to start early, especially for the younger listeners. Maybe who haven't even started their families and have the money to be able to save and do all these kinds of things. You know, once you start your families, money can this is more of financial wellness, but it's like things will start to get harder. There's more expenses that come up when you're in the thick of raising a family. So if you can start younger, it's always better.
Absolutely. Absolutely. And I think this feeds so well into the Erie Wellness podcast, because you take such a comprehensive approach of not just physical wellness or mental wellness, but let's talk about financial wellness as well.
Mhm.
And there are incredible financial professionals in our community who can really help with this. What I love too is when I have clients come to me and they say, maybe we don't work with a financial professional yet, but do you have any recommendations? And so great, you found one team member, you found your attorney. Now let's start to build out the rest of your team members and really make sure that you have this comprehensive approach to your overall wellness.
Mhm. That's a good point. So once people have their team, how do you guys kind of work together in the best interest of your client?
Yes. Yes. I love when clients come with a team or they want to build a team. If a client comes and I'm the first professional essentially they've worked with, that's completely fine too. I love starting fresh with people. If people come to me and they say, I have a financial advisor and this is my insurance person and whoever it might be, I'll say, that's amazing. And I can talk about why for certain reasons. I will need my client's permission to be able to share with their other professional that I'm working with them as a client, and
Mhm.
making sure that they're okay with that I'm talking with their other professional. But where this really comes in is in terms of talking about funding a trust or naming beneficiary designations. So a lot of times they'll work with a financial professional and they'll say, oh, they handle all my accounts. And I'll say, great, here's a list to give to them. Or if you're comfortable, I can email them directly and just say, can you make these updates to the accounts? I really love that approach. And going one step farther too, if someone's more comfortable and they say, look, I'd love to do a consult with you or an initial meeting, but I want to bring in my financial professional, in my
Mm.
opinion, the more the merrier. Let's get us all together in one room. That is going to be what's best for you to get all of your team members together and talking. So starting younger, building out that education is really incredible. I thought you
Mhm.
brought up a good point too of when we were younger. I think you said you and your partner when we were younger, we were just trying to figure things out and life was less busy. And I think where I see a lot of people is, oh my gosh, I'm 20, I don't have many assets, I don't need to do an estate plan. And I was one of those people where I thought, oh my gosh, if I pass away, anyone can take my student debt if they want it. And the one thing I own is a bicycle, and I promised that to my brother or whatever it is. What is often overlooked, though, is the incapacity piece. So if you are incapacitated, if you end up in a coma, if you have a severe traumatic brain injury and have not done planning, well, who's making the medical decisions for you? Who has the legal and financial authority to step in on behalf of you? And as parents, this is what really scares me too, is we don't realize, I think, that when our children turn 18, right, we lose that piece of, I would say, legal authority over them. So if your
Mhm.
child goes off to college, and heaven forbid ends up in the hospital, you don't necessarily have the right to talk to their doctors or to make medical decisions for them. And so
Mhm.
we're planning for younger individuals as well, for college age individuals is incredibly important.
So you would set up like if something happened to you in college, you would have a plan in place. What would that look like?
That's a great question. For college aged individuals, and where I see this come up too is it tends to be my clients and they say, oh my gosh, my children are in their 20s and they actually don't have anything in place. They'll
Mhm.
bring them in and I can work with them as well. I offer, it's essentially for college age individuals and young adults, an incapacity plan. So we want to make sure that if they end up incapacitated, that an individual they want has the authority to make legal and financial decisions, has the authority to talk to their doctors. A lot of times that's still their parents, right? If something happens to me, if I'm 21 away at college and end up in the hospital, yes, I want my mom to be able to come and talk to my doctors and be by my bedside. It's just scary because people don't quite realize that until it happens. And then they're
Mhm.
scrambling. And now they're asking a court for permission to allow the mom to talk to the child's doctors. And I say child, right, a 21-year-old, but I'm like, my daughter's still going to be my baby even when she's 40.
Mhm. Absolutely.
Yes, we really want to focus on the incapacity piece for young adults. They might not feel that they're ready to do a will. I can talk more about, let's just make sure beneficiary designations are set up correctly, but I really want to make sure those incapacity documents are in place.
Right. Because, days can seem like years when you're in a crisis. So taking care of it ahead of time so that you can be there for your babies, even when they're young adults. So,
Absolutely. And if your child, whatever age, right, even 30, ends up in the hospital, as a parent, the thing you're going to want to do is be by their bedside, right? Holding their hand and not trying to deal with the bureaucracy and legal side of, well, can you give me permission so I can talk to their doctors and be in their hospital room? And what does that look like? So
mhm.
you just want to make sure you have everything in place because days can seem like years so that you can be there and take advantage of every second you have with your child.
Well, thanks, Emily, for educating us just on, like you said, their options. Like you need to know that these things exist, and you can decide as a family if they're, something you want to pursue right now or later. So for someone who is listening and realizing that this is something that they've been putting off, can you walk us through the services that you offer? What makes your firm unique, and what can someone expect from a life and legacy planning session with you?
New parent law offers comprehensive estate planning. And when I talk about comprehensive estate planning, it's not just a will, it's not just a trust, it's a lot of additional pieces to make sure that plan will work for you. When I talk about additional pieces, for example, I'm talking about we work with each client to prepare a family wealth inventory. This literally is a spreadsheet of how their wealth is held, their different assets. The thought here is if something happened to you, if something happened to you and your partner, does anyone know where your assets are held, right? Do people know that you have a 401k at this financial institution, or you use a checking account at this financial institution? My 3-year-old would have no idea, and nor should she. She's focused on being a child. But what I want to make sure is that if something happens to my clients, none of their assets get lost. Right now in the US, there's over $58 billion of unclaimed property. Where that happens, for example, Lauren, did you have a job in high school?
I did, yes.
What did you do?
I was a lifeguard. That was a big one that I did in the summer months. And then I worked at Red Robin.
I love that. I was also a lifeguard and a waitress and loved it. And so when I think about, as we're doing that, especially in high school, well, I lived at my mom's house in New York, and I would get mailed checks for my pay. And if I ever did not deposit one of those checks, let's say I was back at college, that money's technically mine. So my employer can't take it back, and that money could end up in what's called unclaimed property. Where we tend to see the most assets accumulate in unclaimed properties when someone passes away, their assets get lost. Unfortunately, I've heard repeatedly from clients that their parents have passed, and it has been a wild scavenger hunt to try to figure out where their assets are located. What it looks like is we prepare a family wealth inventory. So if something happens to one of my clients, we have now detailed where each of those assets are. So we will not lose property in unclaimed property. That's one aspect, for example. Another piece is I send out a letter to every individual my client names in a plan, as long as they're okay with it after the plan is put in place. What that looks like is our firm will send a letter to whoever's named as guardian, who's ever named as successor trustee. That's really important for 2 reasons. One, I want that individual to know what their role is. So if something happens to my client, that individual is ready to jump in. They're not running around all confused. They say, oh no, I know I've been named as guardian, or I know I've been named as successor trustee. The other reason that's important too is if something happens to one of my clients, there will be questions. That's just what happens when someone passes away. Well, now the people named in their plan know what attorney the client worked with. They can come to us. And then we also keep an electronic scanned version of all of our clients' documents. So if something happens to a client and someone can't find their trust document or their will, they now know to come to us, and we have a copy of that. So when I talk about comprehensive estate planning, it's really these little pieces. What's really important to learn that I forgot to cover earlier is we had talked about long-term guardian, but we didn't quite talk about temporary guardian. And so a lot of estate plans, more traditional estate plans, will not name a temporary guardian. It's just overlooked. This is incredibly important though. And a temporary guardian jumps in if, for example, you don't come home from a date night, or you and your partner don't, right? Or you end up in the hospital. Well, who has legal authority to be with your kids? It likely is not that 17-year-old babysitting your children. And so what we risk is showing up. And then the police, if there's no one else, taking your children into child protective services, if even for a night. We don't want your children obviously pulled out of your beds. We want a neighbor to come over, a friend to come over. Maybe it's a family member who lives 20 minutes away. But we want to make sure we have legal documentation of temporary guardianship, that you have given temporary guardianship to these individuals if it is ever needed. And so these are all the pieces of the comprehensive estate plan that work together. So the Life and Legacy Planning Session is a 2-hour meeting. I tend to do it in person. Our firm is located in Old Town Lafayette, so just about 10 minutes for most clients coming from here. Pretty easy. It is a chance to come in, and we will spend the first half of the session talking about the specifics of your family and your estate. So I'll say, tell me about what your family looks like. Tell me about how your wealth is held. What do the different accounts look like? I ask clients prior to do a questionnaire, a little bit of homework, so that when they come in, we can make the most out of that meeting. That's a really good chance to talk through, well, these are your options. This is what a will would do. This is what a trust would do. This is what it looks like with your family structure if you have no plan in place, right? Are you married? Are you married with a blended family? Do you have kids? Do you have guardianship? what about your pets too? What does it look like for them if something was to happen for you? So we talk about the specifics, and then we'll talk about different options. I offer 3 different packages for clients, depending on where they feel comfortable and the level of protection they want to provide their families, and also price. So there's something in there for everyone. And then if they do want to move forward, we spend the second half of the life and legacy planning session starting to actually design their plan. And so this is really, we want to make it as easy and simple as possible for our clients. I realize the enormity of the topics we're talking about and how overwhelming it can be. And so we make it step by step as easy as possible for our clients to work through. And then it's really important for me as well to provide that education for clients and prospective clients. I want them to know what their options are. I want them to know what a will does. I want them to know what a trust does. And then I want them to be able to pick which is best for their family so that they have the information. They know more than I ever will about their priorities, about their family, about their assets. So I want to provide them with the information so they can make the decisions that are best for them and their family.
Such an important conversation, and one that really reminds us that taking care of our future is a big part of our overall wellness. So thank you so much, Emily, for sharing your expertise with us here on the podcast today and just educating our community on all of these topics. It's so amazing that we get the opportunity to learn from these local wellness professionals that we have in our area. So thanks so much for being on the show.
You're welcome, Lauren. It's been a pleasure to be on the Erie Wellness Podcast. Thank you for having me.
All right, friends, before we wrap up, here's the part I need to share. This podcast is for educational and inspirational purposes only. I'm just your friend behind the mic. Nothing shared on this podcast creates a patient relationship with any of our guests or replaces the guidance of your physician, professional coach, or other qualified expert. And the views shared by guests are entirely their own and don't necessarily reflect the beliefs or values of the Erie Wellness Podcast. My goal is to simply create a space for real, open conversations that help us all learn, grow, and feel a little more connected on our wellness journeys. Thanks so much for listening. I'll see you back here next time. Thank you so much for listening to today's episode of the Erie Wellness Podcast. If something from this conversation resonated with you, I hope you'll take it with you into your week or share it with someone in our community who might need it. To subscribe, just head to the main page for the Erie Wellness Podcast, right where you're listening, and tap subscribe. And don't forget, when you start to feel better, you start showing up better in all areas of your life, and you deserve that.